Right, good afternoon, everybody. I'll just move around to check that the microphone's working away from the rostrum. Lectern, all good. Can I just say, when Mike asked for a show of hands about how many people were still in the accumulation phase and sort of working towards retirement, I think it was the bulk of the room, Mike, wasn't it? Is the majority. So presumably normally on a Wednesday afternoon you'd be at work or building your businesses or whatever. So really appreciate, and I'm sure the other guest speakers do, very much appreciate you spending your time out today to listen to us. In the words of Monty Python, we're now going to look at something completely different, executorship. Just before we start, can I ask, again, show of hands, sort of continuing the theme, how many people here have actually been an executor in their lives? Big proportion, actually. And thank you. And how many people have actually appointed executors through their will or through other means? Great. Okay, I'm sort of preaching to the converted. Purpose of today is really just to talk about, as the slide suggests, the process and the pitfalls. So it'd be interesting for you to, in your own minds, compare what you went through when you were executors, and perhaps if you were aware of some of the pitfalls that I'll go through today. What link has this got to retirement? Well, Close Brothers, our sort of demographic of clients is very much similar to the people in this room. So those towards the end of their working lives and those just going into or already in retirement. And the feedback we've had from a lot of our clients, existing clients, is that along with all the other financial issues they need to consider, eking out income from investments, do they have sufficient retirement income when they retire? It's always also looking at the full spectrum of writing a will and whether they've got everything in place for ultimately the day when they'll fall off the perch. So that's what we want to look at today. Introduction, my name's Patrick Haines. I'm a regional director at Close Brothers. We've been delighted to sponsor the Retirement Money Show here for, I think, since inception, actually. So we've presented on ethical issues, ethical investment, and on flight path or glide path retirement planning, which I won't go into today, but it's an American concept. So this is me. We have a stand out in the hallway there, so if you haven't visited us already, feel free to. My disclaimer's at the beginning. So in terms of, if you haven't seen or if you're not familiar with Close Brothers Asset Management, we are one of three divisions of Close Brothers, the Close Brothers Group. Been trading since 1878. Started with the gold rush over in the States. The biggest division is banking. And the nice link here to James's presentation is we are primary supporters of SMEs. So where SMEs, particularly during the financial crisis, couldn't get lending from the big banks, they often came to Close Brothers. So that's the largest part of the institution. Securities on the other side, we've got Winter Floods. If you've heard of them, they're a market maker. The buying and selling of shares, keeping that liquidity within the market. And then the division I work for, which is asset management, which is primarily investing clients' capital and providing financial planning advice. And it's really the financial planning advice bit I want to cover today when we talk about executorship. So this isn't an exhaustive list, but some of the things that Close Brothers gets up to is, well, we've got portfolio reviews. So if you have a SIP, for example, with AJ Bell or your SIP, then it's looking at what's happening under the bonnet, portfolio consolidation, tax-efficient investing, inheritance tax planning, long-term care. We've actually had an inquiry this morning this afternoon earlier from long-term care, and management of trusts. But it's that bottom left area that I want to look at today, which is advice to beneficiaries of trusts and executors. Now, when we started on this journey earlier this year, we put a survey out and had some sort of consumer groups, not just our existing clients, but other people, came along to a sort of hotel or conference centre like today, and we asked them a number of questions about executorship, how they felt about it, what they'd experienced from it. And it's interesting, some of the feedback. I'll just read a couple out. So the key question was, would you or your executors welcome guidance and support on the duties of an executor? And it was a unanimous yes. Some of the answers, the replies, we had Carol L. My father is a single gentleman, and I'm fairly sure that I'll be named the executor of his estate, though this is not something we've discussed. I'm not sure whether it's a conversation I should have with him. I'm concerned it could be misconstrued, that he would think I'm talking about it for the wrong reasons. I also don't know what I would find when it comes to sorting through his paperwork. Pauline I said our son is executor. He would need help and support to execute his duties. Therefore, guidance and support would be really important. Another one here, I had to manage probate for my mother's estate and did not fully understand the process. I called the probate office for assistance and the person there could not answer my questions. Anne M, as an executor to my late husband's estate, I went through a lot of pain. I don't want my son to have the same experience, and I would want to direct him to a suitable place for guidance and support. And lastly, it would be important for me for my executors to receive guidance and advice on different assets and options post-death. So you can see there's a sort of a groundswell there of people actually wanting guidance and advice. And these are people who've been executors already, and they just found there wasn't an awful lot of advice on offer, other than professional executors, where, of course, you've always got the option to go to a solicitor. So in terms of the executor education programme, which we are running now as a service for both clients and non-clients of Close Brothers, some of the things we cover on the programme, and I should just stress before I forget that to take part in this programme and attend one of these sessions, it's without cost to you as individuals. You just need to know where and when they're taking place. So the responsibilities and duties of executors, that's covered, which is pretty relevant, I think, because a lot of people don't realise you're actually ultimately liable when you're an executor. So if anything goes wrong, or I suppose a good example would be if you distribute the estate to the beneficiaries as an executor, and the computation you've made for example, inheritance tax is wrong, and actually you need to ask for some of the money back from the beneficiaries. If they don't pass it back to you, which they may choose not to, or they've spent it, ultimately as executor, you would need to make up the difference. That's just one example where you need to be aware of the responsibilities and duties. Applying for probate, the actual mechanics of it, which can take some time, and there's a fair bit of paperwork. You can do it online. There's a lot of people now who are looking at the internet and trying to do probate themselves. It is possible, but it's fraught with danger. Tax issues and estate accounts. So you're probably aware that as an executor you would need to complete the tax return of the individual before they died in that tax year since 6th of April, and then you would need to complete an estate tax return post-death for the period from death to the end of that tax year. So there's a bit of paperwork there and liaising with the tax authorities. Protecting estate assets, and what comes with that is inheritance tax planning. So there's plenty of, any solicitor will tell you, there's plenty of planning that can take place post-death. You're probably familiar with post-death variations, but there are other bits of planning you can use, discretionary will trusts, etc. But as an executor, again, you need to know what the options are. Disputes and contentious matters. Solicitors tend to make more money, far more money these days, out of contentious matters, disputed estates, rather than actually drafting of wills and lasting powers of attorney. So that's one to avoid. A friend of mine's actually been involved in contentious estate at the moment, and the legal bill, if it had gone to court, would have been around £200,000. So obviously executors want to avoid that wherever possible. We go through a case study as well on the programme, a real-life case study, just bringing things to life. I might touch on that later if there's time, and then just running through the Close Brothers service in terms of the other things that we do. So one of the first things any executor would need to do is to identify the assets of the deceased. Bricks and mortar, title deeds for the property. Are the title deeds lodged with the will? Where is it? Is there a mortgage? Who's the lender? So administrative issues like that. You'd probably need to rifle through the house and just see, particularly if it was a sudden death, and just see whether the papers are there. Did the deceased leave a list of assets? Most people do not, or if they have left a list of assets, it's either online or you wouldn't be able to find it. It's hidden away somewhere. So that's an issue, and we have a solution for that, which I'll mention in a few moments. And the main types of assets are not an exhaustive list. We've got property there. Just remember rental property. So one of the pitfalls or liabilities is if you're an executor and the deceased had a rental property which has tenants still in it, effectively you become a landlord by default, and you have to adhere to all the rules and regulations and laws associated with being a landlord. until the tenants leave. So that's just, again, another example of being mindful of your responsibilities in the role. Bank accounts and ISAs. We've now got this additional permitted subscription, APS, which hopefully you're aware of. This is the ability to inherit your deceased partner's ISA portfolio. My father died in 2010, and this is before the APS was introduced. So his ISA portfolio had to be disinvested, de-ISA'd, so it's suddenly taxable. And my mother, his surviving spouse, had spent the last 8 years re-ISAing what was in an ISA already in his name. So a little bit frustrating for her. So now you don't have to be worried about that. You can inherit your deceased partner's ISA portfolio in its entirety. But it's another good argument to be built. Make sure both of you, if you're a married couple or civil partners, to build up ISA portfolios each, if for any other reason, just to inherit that when one of you dies. Bonds, particular types of bonds, investment bonds, fraught with tax issues, the computations for income tax on investment bonds, and a lot of people hold these instruments. I've seen lots of accountants make errors in this, which is a big problem. And again, as an executor, you would need to make those computations, do those computations. Premium bonds, life insurance policies, are these written under trust? Who are the trustees? Getting in touch with the beneficiaries, lots of issues there. And shares, dividends, scrip issues, having lots of little bits and pieces coming through post-death, which can be a massive administrative nightmare. So there'll be other things there, pensions, state pensions, private pensions, occupational pensions. I think we're due to hear from somebody on defined benefit pensions in a minute. So you need to establish exactly what they were. Can they be inherited by a surviving spouse? So do you need to be distributing those in a certain way or within certain time limits to beneficiaries? Hopefully you may be aware of pension freedoms, which was introduced a couple of years ago. It's possible now to inherit a private pension plan. So again, executors need to be mindful of the rules relating to that. Foreign assets, foreign jurisdictions have some quite specific rules with regard to property, particularly bricks and mortar. So even though the individual may be UK domiciled, if the bricks and mortar is sited elsewhere, again, different rules and regulations apply. Guess what? As an executor, you have to abide by those rules. And digital assets, I was with some people some time ago, and they were telling me a story about a neighbour of theirs. The gentleman had passed away. Everything he held and his wife held was online, usernames, passwords. He hadn't written a list at all, and nobody knew where to look. So even if they'd had usernames and passwords, you need to know the institution to put the username and password in. So what's come with advancement with the internet, the deficiency there is actually not knowing where your assets are held, or often the surviving spouse not knowing where the assets are held. And then identifying debt. So once you've looked at the assets, what are the debts? It could be a number of these, but care home fees is quite a common one. Is the care home, if they're paid annually in advance, for example, or annually in arrears, is there money owing to that care home? How much? Utility accounts. One thing we haven't put on there, actually, charities. So charities, as an executor, you may well be contacted by charities, and they'll be saying, we understand, or we are aware that we are one of the beneficiaries under the deceased will. So can you tell us in the nicest possible way when we're going to get our money? And then gifts. This is really a nod to inheritance tax. Executors need to be mindful of or aware of the inheritance tax rules. Were any gifts made in the past 7 years, outright gifts or gifts into trust? Actually, were any gifts made in the last 14 years? There's a 14-year rule which applies. If you're not familiar with that, it's worth just Googling 14-year rule. It can apply under certain circumstances where gifts are made outright gifts are made in conjunction with a chargeable lifetime transfer. And then there are some exemptions I put there just as a mention. There, it's not an exhaustive list. So gifts. So we've looked at assets, liabilities, gifts, and accepting an executorship. Key thing here is you don't have to do it. If somebody's appointed you in their will to be an executor, you can decline. So it's an important point. I would say if you don't know the person very well, and you've got a very little understanding of their assets, I would think carefully about accepting executorship. So if we put their knowledge and understanding of testator's will, estate, their assets, their family circumstances, executor and trustee can happen. Is there a conflict of interest there? Capability and willingness. You know, do you have when you were in your career, do you have the background, that attention to detail to deal with the administrative issues and the tenacity, because that's sometimes what's required. Have you seen the will? Do you know what's in it? Is it very complex or straightforward? Do you need to bring in the services of a solicitor, an accountant, or a financial planner? And as I said, you don't have to accept. So what we've devised in conjunction with the Executorship programme is the Wealth Legacy Service. And essentially what this is it's a repository to put all the individuals, while they're living, all the individuals' assets and documents. So some of the documents, the obvious ones, lasting powers of attorney, copy of the will, trust documents, schedule of assets, all of those things. It's one place where these could be held prior to death, and then the idea is the executor would then contact us and we could hand over all this information once obviously various checks have been gone through. So you've got everything up to date to actually do your job as an executor. So that's just a list, again not exhaustive, of some of the things that would be incorporated within the Wealth Legacy Service, which we find, we've actually done a survey on this, there are very few, and I've spoken to solicitors and private clients, and there are very few, if any, wealth management firms offering this type of service. You'd expect your financial planner to hold a list of your assets, particularly those assets that they have custody over, but does it involve the villa in Spain? Does it involve the fine wine? Has it got a copy of the lasting power of attorney on record, copy of the will, copy of the beneficiaries, and so on and so forth? In the main, I would say probably not. So, how does it work? So it's an electronic document storage system of not just the assets, but those documents. So they're effectively scanned on, held securely. So we actually subscribe to all the relevant, including the beloved GDPR, which you've heard of in the last few months. So we're ticking all the boxes in terms of holding that information securely, and it's there simply for the executor to tap into on death. So the mechanics are the executor contacts the Wealth Legacy Service team, they identify, they go through an ID process as you'd expect, and then the content of this storage facility for the individual, for the deceased, is then passed over to the executors, and then they can get on with their job. Crucially, the last point is that we would assign a financial planner to the executors so that they could call on our expertise if they needed them during that journey, which is typically 6 to 12 months, while they're winding up the estate and distributing the assets. So we're on hand to assist at that time. We issue the executors, or more likely, we issue the client to then pass to their executors a sort of ICE card, or a bit like a donor card. They pass that so that they've got all the relevant information to contact us and contact the Wealth Legacy Service in the event of death. So view this as passing the financial baton across to the executors. The case study, there won't be time today, but the case study that we cover on the programme, the seminars that we run on executorship, we'll look at case studies. It may be a different case study each time, but essentially giving you a real flavour of how the programme and how the Wealth Legacy Service has specifically helped individuals and executors at this difficult time. So just to finish off, in terms of people in their latter years in retirement, we've found that there are at least 4 areas that people want to consider: desired or ideal income, ensure they don't run out of money. Again, the long-term care issue is always in the background, or can be. The risk that individuals are willing to take with their investments, and how much residual value do you wish to pass on to your heirs. There is an argument to ensure there is absolutely nothing to pass on to your heirs, and you've had a fantastic time. So things to, just click through that. Things to consider to finish off: how much risk do you wish to take with your current portfolio? Have you considered the inheritance tax position, particularly regarding pensions, but other assets as well? Leaving yourself enough cash for day-to-day expenses when you're in retirement, and the tax issue. Remember, there's a dividend allowance now, and also remember that capital gains fall away on death. So there's a strong argument to pass assets that are pregnant with gains to somebody who perhaps is not in prime health, because those gains, those taxable gains, will die with them. And things for you to consider. Do you know how your investments are made up currently? Are there any embedded capital gains within your investments? How do you plan to make use of your ISA allowances each year? Is your estate arranged as efficiently as possible for inheritance tax? Would you wish to reduce the amount of paperwork you have? And are your executors aware of how your estate is made up? And remember the access code online, who has them, because somebody may well need those in the future. And feel free to visit the Close Brothers stands just outside stand number 4. We'd be delighted to see you. Thank you.